Good morning. Today we are going to discuss the topic discharge of contract. But before that, in the previous lecture, we were till section 61. Okay. Now from section 62 to section 67, one topic is there which is called as contracts which need not be performed. Okay. Contracts which need not be performed. That is section 62 to 67 relate with this concept. Now what is section 62? Effect of novation, rescission, alteration of contract. Novation means a new contract. If a new contract is been entered into, if the contract is rescinded, if the contract is been altered by the consent of the parties, then the contract need not be performed. Okay. Section 63 is telling about promisee may dispense with or remit performance of promise. Means the promisee can tell that promisor, okay, don't perform the contract or give a smaller amount. He means what he is doing, he is remitting. For a contract was there of 1 lakh rupees, the person was going to pay 1 lakh, but the creditor himself is telling, okay, don't give me 1 lakh, give me just 95,000 cash, so I will relieve you from the liability of 1 lakh. That is called as remission. Means by remission also the contract need not be performed. Okay. Now these type of concepts means where the liability, where the obligation in the contract come to an end. That is discussed in these sections. Therefore, the heading of the topic is what? Contracts which need not be performed. And if a contract is cancelled, if the contract becomes void and the person has received some advantage, then what he has to do? He has to give it back. He has to restore it. That is mentioned in section 65. Okay. Obligation of person who has received advantage under void agreement of contract void agreement or contract that becomes void. The person has to restore it or make compensation for it. That is mentioned in 65. Okay. Now section 64, consequences of rescission of voidable contract. If a contract is rescinded, it is cancelled, what are the consequences? If advantage is received, that must be given back. If loss has occurred, that must be compensated, isn't it? And the rescission, the cancellation should be informed to that person. Okay. These type of provisions are there. Section 66, mode of communicating or revoking rescission of voidable contract. We have previously seen communication. The topic of communication is there. Communication of proposal, communication of acceptance, and communication of revocation also. So section 66 is telling that same rules will apply as to communication or revocation of proposal. The rules of communication or revocation of proposal will apply for communication or revoking rescission. Okay, that is mentioned in 66. 67 states effect of neglect of promisee to afford promisor reasonable facility of performance. If the promisee is going to give some facility to the promisor, then only the promisor is going to perform the contract. If the promisee neglects to give the facility, the promisor is relieved from the liability of performing the contract. That is mentioned in 67. If any promisee neglects or refuses to afford the promisor reasonable facilities for the performance of his promise, the promisor is excused by such neglect or refusal as to any non-performance which is caused thereby. That is mentioned in 67. So section 62 to 67, that relates with the topic like when a person is relieved from the liability, relieved from the obligation to perform the contract. In a simple manner, this is called as discharge of contract. Discharge means putting an end to the contractual relationship. Okay. Discharge means extinguishment of liability, extinguishment of obligation, end of contractual obligation. That is discharge. Discharge of contract means termination of the contractual relationship between the parties when it ceases to operate, when rights and obligation created by it come to an end. That is called as discharge. Okay. Now there are 6 different modes of discharge of contract. We'll go one by one. Okay. Now the first mode is what? Discharge by performance. What is performance? We have seen in the previous lecture. Performance means doing the thing which the person has agreed for, isn't it? Means the newspaper, the boy who is giving newspaper to us, he has given newspaper for 1 month to us, and we have afterwards paid him the money. The liability has come to an end by performance. Means the terms and conditions, the obligations of each and every party, when they perform it, the contract is fulfilled. The contract comes to an end. Nobody is now liable, because no question of liability comes, because both the parties have fulfilled their promise. Okay, that is called as performance. Discharge by performance is the first mode. Discharge takes place when the parties to the contract fulfill their obligations. Parties are discharged and contract comes to an end. But if only one party performs the promise, he alone is discharged. Other party gets a right of action. Who is guilty to, he is having a right to file a case against the other person. Okay. Now what are the usual mode of performance? The usual mode of performance is actual performance. Actual performance means the example which I have given you. The boy has given us the newspaper. Daily he comes and he gives us a newspaper. He is actually performing his terms of contract. And after 1 month, what we have done? We have also actually given him money. Okay, paid him. So actual performance should be complete, precise, according to the terms of agreement. This is the first usual mode of performance. Okay, and the other is what? Attempted performance, or which we called as a tender. Attempted performance means when a person offers from his side to perform the contract unconditionally, absolutely and all, but the contract may not be performed. It was just an attempt, but from his side he has done 100%, but the other person has denied. Because of the denial of the other party, the contract was not performed, but the person who was performing, he has done everything from his side. So he is relieved from the liability. His liability is discharged. This is called as attempted performance or tender. Offer to perform. Tender is equivalent to actual performance. Contract is deemed to have been performed. Okay, this is the first mode of discharge of contract. Okay, now the second mode is what? Discharge by agreement or consent. It is the agreement by which the contract comes into existence, isn't it? Agreement plus enforceability in law is equal to contract. Therefore, it is an agreement by which the contract comes into existence. Similarly, by an agreement, the contract can be put to an end. As it is agreement which binds them, so by their further agreement, or you can say consent, the contract may be terminated. This principle is mentioned in one maxim. The maxim is idem modo quid constitutor, idem modo destitutor. I'll repeat, idem modo quid constitutor, idem modo destitutor. The meaning is, a thing may be destroyed in the same manner in which it is been constituted. Two persons, they come together, they agree for something, they are having a legal offer, legal acceptance, everything, legal rules are being fulfilled. The contract comes into existence because agreement plus enforceability in law is there. Similarly, both the persons before performance, they come together and they agree that they are not going to continue in the contract. They cancel it, they rescind it. Means by an agreement, they are relieving both the other person from the obligation. This is called as discharge by agreement. Got it? Means by the same mode by which the contract comes into existence, by the same mode it can be put to an end. Okay, now this agreement, or you can say discharge by agreement or consent, can be done in different manner. That is novation, rescission, alteration, then remission, then waiver and merger. Okay, Means here also there are 6 different modes by which you can say the contract is discharged, and that comes under discharge by agreement. Okay. Now that we are going to see in the next video. Means we have today just seen one mode of discharge of contract, and that is what? Discharge by performance. The second mode, that is discharge by agreement or consent, we'll see in the next video. Okay. Bye bye. See you.